Hello students, I welcome you all to lecture number 6 in family law. Now we are done with Hindu law as well as Special Marriage Act. Now let us go to Muslim family law in India. What is the family law, Islamic family law or Muslim family law in India? So like we began with Hindu law, this law is applicable on Muslims. As the name suggests, this law is applicable on those people who believe they are Muslim, who are Muslim, or who profess or propagate Muslim philosophy. Okay, so they are called Muslim, and this is the law applicable on Muslim people. Like we discussed the sources of the Hindu law when we discussed Hindu law. Likewise, manner we'll discuss the sources of the Muslim law as well. How do we get this Muslim law? Okay. Now let us see first source is Quran. Okay. So the first source of Muslim law in India is Quran. Okay, these are ancient sources. Okay, Quran. The root meaning of Quran is Arabic word Qura, the reading. Qura means the reading. The Quran is the reading. Who's reading? Quran is the word of God. Okay. Revealed to Prophet Muhammad. Prophet Muhammad happens to be the first prophet of Muslim law. Okay. First prophet of Islam who established this religion as Islam. So God revealed something to Prophet Muhammad and he kept on writing and then Quran came up. Okay. Through angel Gabriel. Okay. Through angel Gabriel. God revealed to Prophet Muhammad via through angel Gabriel. Quran is primary and fundamental source of Islam. It is the most basic and fundamental source of Islam. It consists of 6237 ayats. Ayat means a verse. Okay, a verse. Verse means two rhyming lines form one verse. Okay, two rhyming lines in a poem are called verse. They are one verse. Okay, so there are 6237 verses in Quran divided into 114 surahs, that is chapters. Okay, divided into 114 surahs or chapters. It is regarded as Al Furqan, the one that shows the truth from falsehood and the right from the wrong. Quran is regarded as source of light, Al Furqan, okay, which separates truth from the false and right from the wrong. Okay, it's a source of light or illumination for all Muslims around the world. Traditions of the Prophet. Second source is traditions of the Prophet, Sunnah and Hadiths. These are the traditions of the Prophet. Whatever tradition Prophet used to follow, the followers started following those. Okay, they are called Sunnah and Hadiths. Sunnah is equal to trodden path. Sunnah is equal to trodden path. Okay, it refers to the actions and sayings of the Prophet. Okay, so whatever Prophet did himself, okay, in his own life, it set an example for others to follow. Okay, so that is the trodden path of Prophet is called Sunnah, outside revelation. Okay, now one is Quran, but what not is in Quran is the tradition of Prophet. What is not available in Quran, then they will try to find the answer for the trodden path of Prophet. So whatever Prophet did, people follow. Hadiths are the compilation of Sunnah. Sunnah are trodden path, anecdotes and stories or examples how Muhammad did something. Now, when you will compile them into one book, then it is called hadiths. Okay, hadiths are compilations of Sunnah, recounting incidents of Prophet's life. Okay, they recount incidents of Prophet's life. The Prophet's acts and words are believed to have been inspired by God, though it is not a part of revelation. Okay, so these hadiths and sunnahs, they are not part of Quran, they are not part of revelation. Quran is revelation, pure revelation. What God said is, Quran is pure what is God saying. Now sunnah and hadith, they are outside revelation, but they are act of the Prophet which are supposed to be done by the inspiration from God. So wherever the Quran is silent, the hadiths which contain the sunnah are the next source. Okay, so first source is Quran. If something is not available in Quran, then we will check with sunnah and hadiths. Sunnah are graded into several categories. Now sunnahs have categories. What are the subcategories of sunnah? Sunnah ul Qawl. Okay, Sunnah ul Qawl, the words spoken by the Prophet. So now people have written down the words spoken by the Prophet and they are called Sunnah ul Qawl. Whatever Sunnah whatever Muhammad said. Sunnatul Fa'il. Okay, Sunnatul Fa'il. The conduct and behavior of the Prophet. The conduct and behavior of Prophet Muhammad, how he behaved in one particular situation. So other Muslims are also supposed to behave in that particular manner. That is called Sunnatul Fa'il. Sunnatul Taqrir. Okay, Sunnatul Taqrir. The Prophet's implied approval to pre-Islamic customs and practices, mostly through his silence. Okay, so pre-Islamic customs means there were tribes before Islam came up. Okay, people who did not have their own religion, they had their own practices, not a uniform religion. Okay, so Prophet came and unified them under one umbrella, that is Islam. So whatever they were following before joining Islam, that is called Sunnat ul Taqrir. Okay, so Prophet allowed those activities to be done mostly through his silence. Okay. There are several narrators of hadiths. The Sunnis categorize them in the following hierarchy. Okay, following hierarchy. Now, hadiths means incidents of the Prophet's life. Now, who has told those incidents? Let us see. Companions of the Prophet. Okay, the first person who knows the Prophet very closely is definitely the companions of the Prophet. People who lived with the Prophet and they made an autobiography. They made a biography of Prophet and anecdotes about the Prophet. Muslims who lived with the Prophet during his lifetime and were close to him, their testimonies are the most reliable ones. Okay, because they know the Prophet more closely, so they are most reliable. Successors of the companion, that means children of these companions of Prophet. The Muslims who came in contact with the companion of Prophet, they stand second in reliability. Okay, because Prophet tells these people companions, now companions tell their successors. Okay, so they are first one because they have heard it straightly, heard or seen straight from the Muhammad, and now second because they have heard or seen it from the companions, not directly from Prophet. Third category is successors of successors. Now they are successors. Okay, the Muslims who were in constant companionship of successors, they come last in the line of reliability. Okay, because their source of evidence is now weak because they are hearing from the successors of companions. So now they are successors of successors, and if someone is following them, then he is successors of successors of successor. His reliability is going to be very less. Okay, so if they are saying something, companion of Muhammad is saying that situation X this should be done, and successors are saying in situation X it should be done. So whatever they are saying, we will follow that first. If they are not saying anything, then we will look into them. If they are also silent, then we'll go to them. The farther a narrator from Prophet, the lesser authority is given to his narration. In addition, each narrator was judged by the mental understanding, power of retention, and righteous conduct. Okay, so we are judging each of the person who is away from the Prophet on his personal intelligence as well. Okay, the Shias, that is a section of Muslim. Okay, Muslims have predominantly two sects, that is Shia and Sunni. Like in Hindus, we may say that we have Hindu, we have Brahmin, we have Vaishnav, and so like this, Shia and Sunni. The Shias follow only those traditions that come from the Prophet's family and reject all other hadiths. Okay, so Shias are basically following those traditions which come directly from the Prophet's family and they are rejecting any other kind of hadith. Ijma, that is unanimous decision of scholar. Now, third category of source of law for Muslim is Ijma, which is unanimous decision of scholars. Ijma means the opinion of learned. Okay, those who know the Muslim law, those who know the Islam, their opinion on something. Okay, the opinion of learned. It refers to the unanimous decision of scholars on any issue at particular time or era. When all the scholars, all the learned people of Islam, they come to a common ground on certain issue, then it is ijma. When Quran is silent on an issue, and nothing clear cut or definite can be ascertained from hadiths, persons knowledgeable in law would agree upon a point, which becomes ijma. A major chunk of fiqh or actual Muslim law came through ijma and not directly from Quran or hadiths. Now, a major chunk of Muslim law comes from ijmas, okay, not from hadiths or Quran. Why? Because Quran and hadith they are not as comprehensive as later on these scholars have conducted research and given their opinion. Okay, so after conducting and researching something, definitely more is added to it. So more is added to the Muslim law by ijma. Then is qiyas. Okay, then is qiyas. Analogical deduction. Analogical deduction means similarity, same situation. Identical situations. Qiyas is a method of comparing a problem in present times to a similar problem for which the solution is provided in the text. It is actually a weaker form of ijtihad. Ijtihad, okay. So they are now trying to form comparisons that in that time it was done in this situation, so we will do that thing in today. But because there's a change of time, and like we have understood, society keeps on changing. So whatever was followed earlier may not be valid today. So that is why their authority is considered weak. Okay, but still they are source of law for the Muslim law. Now, what are secondary source of Muslim law? Secondary source of Muslim law, okay, which is weaker than the primary law. Okay, if primary source says something, Quran, Hadith, or Qiyas or Ijmas, if they say something, then it will be understood. Okay, then secondary source of law, custom. Okay, the custom, like we discussed custom in the Hindu law. Similarly, Muslims also have a customary law, which is called urf or tumul. Okay, urf or tumul in Arabic. Before Islam, customary law governed Arabia. Okay, because Islam originated in Arabic countries. So before Islam, customs governed Arabia because people were divided into separate tribes, and every tribe had their own custom. Okay, so before Islam, customary law governed Arabia. The Prophet abolished most of them. Okay, when Prophet came, he abolished most of the customs. Okay, and he unified all of them under one umbrella, that is Islam. But some were implicitly or explicitly approved by the Prophet. Implicitly means through silence, explicitly means actively he approved something. Okay, the British courts in India held that a custom would prevail over a written text provided that the custom was ancient and invariable. If something is written but the custom will prevail over that written thing, only in which condition? When custom is invariable, uniform, not vague and ancient. We discussed in Hindu law, we need not repeat them again here for the sake of time. What are the essentials of a valid custom? So what are the essentials of a valid custom for Hindu law? They are, the conditions are similar for the Muslim law as well. Okay, similar requirements are required for a custom in a Muslim law to be a valid custom. Then legislations. Okay, legislations like we have discussed, acts of parliament, acts of parliament and acts of state legislature. These are legislations. Like now we have, recently we saw India passed prohibition on triple talaq. Okay, earlier triple talaq, the practice of triple talaq, that is divorcing one's wife by saying talaq 3 times. Okay, this practice was considered unreasonable, and court said it is unreasonable, and the union government brought a law over it. Now this particular form of talaq is prohibited, and not only prohibited but punishable as well. But punishable as well. Okay, so these are the acts of parliament. They also become a source of Muslim law. Judicial decisions. The decisions of the judges, they are a source of law for Hindus as well. In British India, the Privy Council decided many cases related to Muslim law. In British India, Privy Council, like we discussed, Privy Council used to be the highest court of the land, highest court for India, and it used to have its seat in London. Okay, so all the matters which went to the highest forum, they went to Privy Council, and Privy Council decided them, and whatever Privy Council decided, it became a law. So the Privy Council decided many cases related to Muslim law. These cases continue to have a binding force on all the high courts and the lower courts in India and have a persuasive value in the Supreme Court of India. Okay, so these decisions are binding on everyone, and Supreme Court, because it is equal to Privy Council now. Okay, it is the highest court of land, it is equal to Privy Council. So they hold a persuasive value for Supreme Court but not binding. But for high courts and lower courts, they are binding. Fatwas. Okay. Now, another primary source is fatwa. A fatwa is an educated opinion issued by an expert in religious law, which is called mufti. Usually, we call them mufti who are expert in religious law. They are called mufti. They issue their educated opinion on particular issue. It is called fatwa, pertaining to a specific issue, usually at the request of an individual or judge to resolve an issue where Islamic jurisprudence is unclear. Okay, sometimes when Islamic jurisprudence is unclear on something, then usually a judge or some individual will approach a mufti because he is a learned religious person. They will approach a mufti and they will ask mufti to assist. Then mufti will issue an educated opinion which is called fatwa. Then mufti will issue a fatwa. Okay, unlike ijma or qiyas, fatwa can be issued by any mufti on how he interprets the issue in his individual capacity. Okay, fatwa compares to a court verdict but is not legally binding to anyone. Fatwa is like a decision of the court. Okay, but court decision is binding, fatwa is not binding. It is up to the people. If they wish to follow it, they may follow. If they do not wish to follow, they may not follow. It is just like in Hindus we have panchayat system. Okay, the panchayat system is head body of the village will take decision and village may or may not follow. This panchayat system is applicable in the Islam as well. Okay, it is called fatwa. It is expected the one who issues fatwa should know the complete Quran and corpus of hadiths. That one who is issuing a fatwa, he has complete knowledge of Quran as well as hadiths. Okay, this is required. Works of scholars, learned people and their works. Okay, whatever they are, whatever opinion they have for Islam, these also a source of law. Works of scholars throughout the ages, codifying the information found in Quran and other sources, are often the first-hand source of information. Okay, for example, Fatwa Alamgir. Okay, Fatwa Alamgir, a compilation of law created at the insistence of Mughal Emperor Aurangzeb, is the source relied upon in India and Pakistan for implementing Sunni Hanafi Islamic Sharia. Okay, so Fatwa Alamgiri, which was on the Aurangzeb's request, Mughal Emperor Aurangzeb, he requested that a Fatwa Alamgir be compiled, and it was compiled on his request, which is still followed as a valid law in India as well as in Pakistan. Likewise, Charles Hamilton's Hidayah. Okay, Charles Hamilton's Hidayah, which is a tradition of translation of Ali ibn Abi Bakr's Marginan. Okay, is also relied upon work for family law in India and Pakistan. Okay, so these are works of scholars, and we rely upon those works. Concept and nature of marriage in Islam. Okay, now what is the concept and nature of marriage in Islam? Nikah literally means to collect and bind together. The marriage in Islam is called nikah. Okay, we call it vivah, they call it nikah. Muslims call it nikah. Nikah literally means to collect and bind together. Just like we vivah says, just like Hindus in vivah says united forever, They are collect and bind together. You collect two individuals and bind them together. That is called nikah. It is basic and most common form of marriage among Muslims. Muslims have some other forms of marriages as well, but this is the most common and basic form of marriage among Muslims in India, and is described in Kunna Surah 4 or 4. Okay. Nikah finds mention even in Quran in 4 of 4. The contract may be in writing or oral, executed by a Qadi. Qadi is the judge in the presence of witness. Now, the marriage in the Muslim law is a kind of a contract, okay, which may be in writing. It may be in writing, like we have discussed Indian Contract Act. Contract can be written or as well as oral. So, a contract can be in writing or oral, which is executed by a Qadi. Qadi is a judge who will write that these parties have agreed to this contract in my presence, in presence of witnesses. Some witnesses are also there. Okay, then the marriage is complete. Legal nature. What is the legal nature of the marriage in Islam tradition? In Islam, marriage is a civil contract. Okay, in Islam, marriage is a civil contract by which a man and woman enter into a legitimate state of sexual intercourse, cohabitation, and procreation. Okay, so in Islam, the marriage is like a civil contract. It is a civil contract that will you marry me? There is an offer. Other person, usually a girl, she will say yes, I will marry you, and the marriage is complete. Okay, so because there is a proposal and acceptance, okay, it is a kind of a civil contract by which a man and woman enter into a legitimate state of sexual intercourse, cohabitation, and procreation. Procreation means bringing up of children, cohabitation means living together. Section 2F of Muslim Women Protections of Rights on Divorce Act 1986 defines nikah as a solemn pact. Okay, mitha ke galid, a solemn pact between a man and woman, soliciting each other's life companionship, which in life takes the form of a contract. Okay, aqd, aqd, which in law takes the form of a contract. Okay, so marriage in the law, the nature of marriage in Islamic law is a contract. It's a contract between man and a wife. Okay. Unlike Hindu law, where the marriage is sacrament. Okay. We have Hindus call marriages sacrament, like a heavenly union, a sacred union which cannot be separated, a union for 7 lives, something like this. Okay. Marriages in Muslims have a nature of civil contract. Marriage is necessary for the legitimation of child. When the marriage is done in accordance to the prescribed norms, it creates various rights and obligations on both the parties. Definitely, any kind of marriage is going to create rights and obligations. Why? Because two people are sharing a space. The social nature of the marriage in Islamic law. In Islam, marriage is also a social obligation. Like in Hindu law, marriage is a social obligation as well. Amir Ali defines marriage as an institution to protect the society from foulness and unchastity. Marriage is considered to be a moral safeguard and a social need. There were several forms of marriages in pre-Islamic Arabia, such as buying of girl from parents by paying a sum of money. These are the forms of marriages we are discussing, which were prevalent in Arabia. Okay, before Islam took up. Okay, buying a girl from parents by paying a sum of money. Okay, or temporary marriages were there, which are temporary for a year, for 2 years, for 2 weeks, like this. Marriages with two real sisters simultaneously. One person marrying two sisters, real sisters, at same point of time. Freeness of giving up and again accepting a woman. Freeness of a kind of marriage in which you can anytime give up your wife or you can again accept your wife whenever you want. These were the kinds of marriages we were applicable in Arabic pre-Islamic Arabia. Islamic laws regulated and reformed such marriage practices. Islamic laws came up, they regulated and reformed such marriage practices. Okay. Conditions of a valid Muslim marriage. Now, what are the conditions of a valid Muslim marriage? Let us see. Under the Muslim law, a valid marriage is that which has been constituted in accordance with the essential conditions. A marriage which is in accordance with the essential conditions. It confers upon wife the right to dower, maintenance, and residence. Okay, it gives certain rights to wife. What are those rights? Right of dower, maintenance, and residence. And at the same time, they also put a duty. They impose an obligation upon wife. What is that obligation? To be faithful and obedient to her husband, admit sexual intercourse with him, and observe iddat. Okay, observe iddat. Now, what is iddat? We will discuss later on. Okay, but meanwhile, these are the duties which are put upon by the Muslim law on a woman after marriage. That is, she has to be faithful, she has to be obedient to her husband, she has to allow sexual intercourse, and she has to observe iddat. And she gets some right. Those rights are rights of dower. That is, some money is going to be paid to her, maintenance and residence. Okay, she can have a roof. Now, the conditions of valid Muslim marriage. Now, these are the conditions. First condition is offer and acceptance. Okay, because we discussed marriage in Muslim law is like a contract. So, the first condition of any valid contract is offer and acceptance. The Islamic marriage ceremony is essentially offer and acceptance. Both the parties are clearly identified by the Qazi. Qazi will identify the party who presides over the ceremony. Okay, he will identify that I have seen the bride, she is the one whose name is mentioned here. I have seen the boy, he is the one whose name and address is mentioned over here. The wali is the guardian or walid. Okay, the father usually. The wali or walid is father. The walid of a bridegroom makes the ijab proposal. Proposal is called ijab. Who says to the groom, I marry so and so to you. Okay, or similar words, something like this. Okay, I marry so and so to you. That means I marry my daughter to you. So and so means name of the girl. So and so is the name of girl. I marry so and so to you. I marry my daughter, suppose Zenat, to you. Okay, the wali will make a proposal. Okay, bridegroom will make a proposal or something similar. The bride makes kabul. Okay, the bride makes kabul. She will say, I accept. Okay, the wali, guardian of the bridegroom, bridegroom's father will say, I want to marry my son to you. And she will say, Kabul, I accept it. Or similar words. The offer and acceptance has to be in single sitting. There is no deferred marriage in Islam. Okay, in the single sitting, it has to happen. It cannot be that kind of a contract where wali of groom made a offer to the girl today and she is replying 3 days later. No, this is not the case. It has to happen in the single sitting at the same time. The process is same for Sunnis and Shias. Both sects follow same kind of process. Akbar Qadir versus Salima. This is a court case. See how old these court cases are, 1886. Okay, but still they are valid. Court held Muslim marriage is a civil contract between Muslim male and a female, and on completion of proposal and acceptance, the rights and obligations apply immediately. Immediately, the moment she says Kabul, marriage is complete. Okay, because it is a contract. So, moment you accept it, the contract is complete. Okay, you need not do anything else. Mere acceptance of contract is sufficient. Witnesses. Sunni jurisprudence requires either two adult Muslim male or one adult Muslim male and two adult Muslim female as witnesses. Now, Sunnis, when they are conducting a marriage, then they say when this proposal was made and it was accepted, then it should be heard or it should be made and accepted in the presence of either two adult Muslim males or one adult Muslim male and two adult Muslim females. But it cannot be four adult Muslim females. No, one adult Muslim male has to be there. At least one male has to be there. If there are four Muslim females and they say no, it happened in front of me, they are not going to be believed. The two Muslim males are there, good. But if two Muslim males are not, then one Muslim male and two Muslim female as witness. Shia jurisprudence requires two adult Muslim males as witness. Shia jurisprudence says two adult Muslim male have to be there. Witness of women is not considered valid in Shia jurisprudence. Okay, witness of women is not trusted. Capacity. At the time of marriage, both the parties must be of sound mind. Okay, unsoundness of mind may be either idiocy or lunacy. Marriage by lunatic during lucid interval is valid marriage. Lucid interval means A person who's usually unsound, but sometimes he's sensible on some occasion or some days or something like this. So when he is going through a lucid interval, that times right now he is sound. So if he conducts a marriage in his soundness, then the marriage is a valid marriage. Ultimately, later on, he may be an unsound person, but when the marriage is happening in a lucid interval, it is a valid marriage. However, a minor and insane who have not attained puberty can be validly contracted in marriage by their respective guardians. But the minors, because the minor is not valid to give a consent. Okay, if minors are going to be married, or you are marrying someone to a lunatic, that who is not in lucid interval, who is right now lunatic, who is right now an idiot. So, on behalf of that idiot, the consent can be given by his father. And for minor, if you are marrying a minor, then on behalf of minor, the proposal or the acceptance could be made by the father. Legal age of marriage. There is no specified legal age for marriage. Okay, there is no specified legal age for marriage in Muslim law. No age at all. Like in Hindu law, we have 21 and 18. They do not follow any age format. Sahih Muslim permits marriage on reaching sexual maturity. Okay, Sahih Muslim permits marriage on reaching sexual maturity. Now, what is the age for reaching sexual maturity? It depends upon person to person. Like for girls, we can see she starts having menstruation cycle, voice has changed, hormonal shifts is there. Okay, sexual maturity in Sharia law is typically understood to mean puberty. Okay, sexual maturity in Sharia law is puberty. Puberty is usually menstruation. In Sadiq Ali Khan versus Jai Kishori, Privy Council held earliest age of puberty is 12 years for men and 9 years for women. Okay, Privy Council in 1928 held that earliest age of puberty is 12 years for men and 9 years of women. That means a woman can marry at the age of 9 and a male can marry at the age of 12. But in Master Atika Begum versus Muhammad Ibrahim, the Privy Council lays down the rule to determine maturity, the completion of her 15th year. Okay, that on majority of cases, on 15th year, girl is valid to marry, girl or boy is valid to marry, or attainment of a state of puberty at an earlier period. If they have attained puberty at an earlier age than 15, then they can marry at that time. Same rule applies to both boy and girl. The Child Marriage Restraint Act 1929 makes marriage of people below 12 years for men and 18 years for women punishable. But like we discussed, women marriages are punishable. Okay, those who conducted the marriage they will be punished. But the minors who are married to each other, their marriage will be valid. Okay, marriage will not be void because they were minor. Marriage will continue to be valid. Consent of the parties, because it's a contract, so consent is material. Consent of both the parties, including the bride, is essential. A marriage without the consent of the bride or performed under coercion is illegal. Okay, if consent is not taken, or if taken not appropriately taken, it is taken under force or misconception, mistake, etc. Okay, fraud, then that kind of marriage is going to be illegal. Hassan Kutti versus Janbah. Hassan Kutti versus Janab. Hassan Kutti versus Janab, 1929. Marriage of a girl who has attained puberty and of sound mind is void if her consent is not obtained. So, marriage is going to be void if the consent is not obtained. Abdul Qasim versus Jamila Khatum, 1940. It was held consummation of marriage held without consent of bride will not validate the marriage. Okay, having sexual intercourse with the marriage without with the wife without taking her consent for marriage will not make the marriage a valid marriage. Okay, there has to be something called mahar. Now, what is mahar? Let us see. Nikah is not valid without mahar, which is dower paid by bridegroom to bride. Dower or money. Mahar is, you can say, money. Okay, this is the price of the bride which you are paying to bride's family or bride. That is called mahar. And marriage cannot happen without mahar, without paying the price for the bride. Okay. Other spouses. Okay. The groom should not have more than four living wives. Okay. In Muslim law, a groom is allowed to have four wives, maximum four wives at same time. Okay. So when he is marrying, he should not have more than four living wives. Okay. He can have total four number of wives. Okay. So when he is marrying, he should not have more than three living wives. Okay. When he is marrying, and if he is married, he can have maximum four. Muslim men are allowed to practice polygamy. Polygamy means marrying more than once. Monogamy is single marriage. Polygamy is more than one marriage. So men can practice polygamy. Okay, that means they can have more than one marriage and maximum four wives they can have. But women must practice monogamy. Women can have only one husband. Okay. Muslim men are allowed to practice polygamy as per Quran, Surah 4 Al-Nisa, verse 3. A man does not need approval of his first wife for second wife. Okay, if man is going to contract another marriage, he does not need the approval of first wife. Even if first wife does not give approval, then also marriage will be a valid marriage. The only requirement is to create fairness among his wives, that he should be fair with all the wives. Okay. He should love all of them equally, he should maintain all of them equally. If this requirement cannot be fulfilled, then he can only marry one woman. The wives under muta marriage do not count towards this limit of four. Now there is a certain kind of marriage which is called muta marriage. So in muta marriage there is no limitation. So muta marriage means he can have maximum four nikah, and he can have any number of muta marriage. Muta marriage is a temporary marriage. Polyandry is, however, not permitted, apparently owing to the potential questioning of paternal lineage. Okay, polyandry is not allowed. Okay, polyandry means more than one husband. Okay, women must have polygamy. Monogamy. Okay, so or we can say monoandry. Okay, monoandry. She cannot have more than one husband. Apparently, owing to the potential question of paternal lineage. Apparently, because it won't be clear as to who is the real father of the child. As such, wife should not have a living husband when marriage takes place. Consent of wali. Now, wali is father, or if father is not there, then the guardian. Permission from the bride's father or guardian, wali, is essential in Shafi, Maliki, and Hanbali schools of Sunni law. It is strongly recommended in Hanafi school. It is obligatory only as a precaution in Shia jurisprudence. So, consent of father is mandatory in Sunni law. If you want to marry, then consent of father is must in Sunni law, but obligatory in Shia jurisprudence. That means you may, in Shia Muslim may have the consent of the wali or may not have it. It is not going to change the character of marriage. Marriage will stay legal. Where consent of wali is required, the bride does not enter into the contract of marriage with the groom directly, and rather enters into marriage contract with the wali who acts on bride's behalf. Okay, the wali will enter into the contract on behalf of the groom. The marriage ceremony in Islam. The essential marriage ceremony in Islam is very short. The nikah is registered by a who performs qadi or qazi who performs the short ceremony, which includes the ijab and kabul. Ijab means will you marry so and so. Kabul is yes, in the presence of the witness. There will be an optional sermon, khutbah as well. Optional. Khutbah is optional. Sermon, that means a religious reading, which is optional, may or may not happen. Unlike the wedding ring in Western societies, there is no visible sign worn to show a woman or a man is married. Okay, there is no sindoor, no vermilion, no garland exchange, or no mangal sutra, or no wedding ring. Nothing is required. But if they want to follow it, they can. Okay, what is only required is ijab and kabul. Okay, but in case they want to exchange wedding rings or exchange garland or do something else, they can. But the essential thing is ijab and kabul. If ijab and kabul is not there, but they are exchanging rings and so all, marriage will not take place. Okay, essential is ijab and kabul. The walima is dinner given by the groom's side of the family to celebrate the welcoming of the bride to the family. It is a strong sunnah but not mandatory. It is a strong tradition that a walima dinner is sponsored by father of the groom for welcoming the new child, welcoming daughter-in-law. It is strong but not mandatory. Now, what is a irregular or fasid marriage? Irregular or fasid marriage. We do not have void and voidable marriage in Islamic law. We have irregular and void marriage. Okay, irregular is called fasid marriage. Failure to fulfill the following essential conditions of a valid Muslim marriage results in irregular marriage. Now, these are those conditions. If these conditions are not fulfilled, the marriage will be a fasid marriage. Means marriage will be a irregular marriage. Such marriages are not legally valid until consummation. These marriages are not legally valid unless sexual intercourse takes place between man and a wife. Okay, if sexual intercourse has happened, these marriages will become valid and can be terminated by any party to the marriage at will before consummation. Okay, when consummation takes place, the marriage becomes legal. Okay, when you have sexual intercourse, the marriage will become legal. A marriage without witness. Okay, so the witness are required for a marriage. It's an essential condition. But if witnesses are not there and you have had a sexual intercourse, the marriage is complete, legal. Marriage of a man with a fifth wife. Okay, marriage of a man with a fifth wife. A Muslim, he is allowed to have only four wives, but if he keeps a fifth wife, that marriage will be irregular marriage or a fasid marriage. But he has intercourse with the fifth wife, it will become legal. Marriage with a woman undergoing iddat. Okay, what is iddat? We'll discuss later on. A marriage with a woman who's undergoing iddat. If some woman is observing iddat is usually a period of purity. Okay, iddat is usually a period of purity. If some woman is observing this period of purity and someone marries that woman during iddat, then the marriage is irregular. Okay, marriage with a fire worshipper. Fire worshipper means people who worship fire, like Hindu, Parsi. Okay, Hindu and Parsi, they worship fire. Okay, marriage with a fire worshipper. So marriage with a Hindu or Parsi is irregular, but sexual intercourse will make it regular. Marriage outcome of bar of illicit sex. Okay, marriage outcome of bar of illicit sex. So you are not allowed to have some sexual intercourse with some particular relations, but if you are having relations with that person as well, which you are not supposed to do, then also this marriage will be legal marriage if sexual intercourse has happened. Now, void is batil marriages. Marriages which are batil are called void. Okay, batil marriage is a void marriage. Void means which cannot be legalized even after having sexual intercourse. Okay. Failure to fulfill the following conditions of a valid Muslim marriage results in a void or batil marriage. Such marriages are illegal from very beginning, does not create any civil rights or obligation between the parties, and the offspring, offspring is children of a void marriage, is illegitimate. Okay, so children born out of these batil marriages are illegitimate children, they cannot be legitimized. Marriage through a forced consent. When the consent of the bride or a groom is taken by force. Such marriage is a batal marriage, a void marriage. Plurality of husband. If a woman is having more than one husband, okay, then that is going to be a batil marriage. Marriage prohibited on the ground of consanguinity. Okay, marriage is prohibited on the ground of consanguinity. That means consanguinity. Okay, means relations by blood, like real sister, brother, father, mother, etc. Okay, people with whom you share blood, they are called consanguine people. Okay, so you cannot marry your sister, brother, like prohibited degrees we discussed in Hindu law. People marriage prohibited on the ground of affinity. Affinity means marriage. Okay, relations which have come up by a marriage. Suppose like father-in-law cannot marry daughter-in-law. Okay, it is like this. Marriage is prohibited on the ground of fosterage. Okay, marriage is prohibited on the ground of fosterage. Foster mother means a mother who is not biological mother but has breastfed the child. Okay, so if some lady other than your mother, she is breastfeeding you, then she becomes your foster mother. So you cannot marry your foster mother. Okay. Now, what is the option of puberty in the Muslim law? Khayarul Buluk. It is called Khairul Buluk. Sorry, Khairul Buluk or Khairul Buluk. It is called option of puberty. Khairul Buluk is the option available to a minor on attaining the age of puberty to approve or disapprove the marriage. Suppose a minor is married and he attains the age of puberty. Now, age of puberty usually is 15 years. Okay, after turning 15, he can approve or disapprove the marriage. If this option is invoked, marriage stands dissolved with immediate effect. Okay, if he says, I want to dissolve this marriage after turning puberty, the marriage will be immediately dissolved. No further act is required. Clarification of option of puberty is optional in Sunni law and compulsory in Shia law. Okay, in Shia law you have to exercise it. In Sunni law you can exercise it by not saying it, but by even staying away from the wife. I mean that means by conduct also you can use this option in Sunni law, but in Shia law you have to verbally state it. The option of puberty is not allowed for husbands. Husbands do not have such option of puberty if his marriage was contracted by father or grandfather, unless it can be proved that marriage was done in a fraudulent manner. Okay, if a child is minor below puberty, before puberty, he is married by his father or grandfather, then the marriage is valid and this male has no option of puberty. A wife can exercise option of puberty even if her marriage was contracted by her father or grandfather. Okay, but this option is available to the wife only. The option must be exercised by the wife immediately after the attainment of puberty, or else the right is lost. Immediately, okay. If she waits for 1 month, suppose she is now 15 years and 1 month old and she has not used the option will go away forever. However, so and so Act allows Muslim wife has a right to exercise the option till she attains the age of 18 years. Now this act which will now prevail, it says Muslim women have the right to exercise this Khairul Bulug option of puberty till the time she attains the age of 18. Okay. A husband has the right to exercise the option until he approves the marriage either expressly or impliedly. Payment of dower to the wife or cohabitation with her is regarded as implied approval of the marriage by husband. If he pays the dower, if he pays the bride's money to the wife, then it is said impliedly he has accepted the marriage. Or if he has consummated, that means he has had sexual relation with the wife, that means he has impliedly approved. The marriage does not dissolve merely by the exercise of option of puberty. Confirmation by court is necessary for dissolution of marriage. Okay, simply because you have exercised your option of puberty, Marriage will not be dissolved. Confirmation of court is necessary for dissolution of marriage. This is the position after this Dissolution of Marriage Act 1939. Before 1939, position was that upon the exercise of option, marriage will be immediately dissolved. But now confirmation of the court is required. Okay. Abdul Qasim versus Jamila Khatun 1940. Option of puberty should be exercised within a reasonable time after puberty, failing which the option to exercise the right will be lost. Okay. Otherwise, the right will be lost. Now, what are the different types of marriages in Muslim law? Apart from the standard nikah we discussed above, there are many other types of marriages in Islam with varying degrees of legitimacy. Okay, they have various degrees of legitimacy. Some are legitimate, some are not legitimate, some are partly legitimate, some are fully legitimate. Okay. Nikah muta. Muta marriage is a temporary marriage. If there is an agreed upon end date in the marriage contract, like you have a contract marriage in which you say that marriage shall remain valid till the end of 2022. Okay, so for till 2022, you will remain as a husband and wife. That is called muta marriage, and after that, you will turn strangers. Okay, that is the muta marriage. Such contract is invalid according to Sunni jurisprudence. Sunni jurisprudence says that this kind of marriage is invalid. However, this is allowed in Shia jurisprudence. Shia law says that this kind of marriage is allowed, and such marriages with an end date are known as muta marriage or temporary marriage. You can have as many number of muta marriages as a male wants to have. Okay, the essentials of muta marriage are: the period of cohabitation should be fixed. For how long will you two people stay together? That has to be fixed. Dower should be fixed. The bride's money. Okay, the money paid for the bride should be fixed. If dower specified, if dower is specified, term is not specified, it could amount to a permanent or regular marriage. If dower is written, but the term of ending of the marriage is not written, it could ultimately be presumed to be a regular marriage. If term fixed, dower not specified, it amounts to a void marriage. If the term is fixed for 1 year, 2 year, but dower is not specified, the bride's money is not specified, it amount to a void marriage or a batil marriage. Okay. Now let us understand the distinction between muta versus a traditional marriage. Unlike a traditional nikah, the couples do not inherit from each other in muta marriage. Okay, in muta marriage, you have no right of inheritance. There is only meher. Meher is dower's bride's money. Unlike regular marriage, husband is not responsible for the economic welfare of the woman, and she usually may leave her home at her own discretion. In muta marriage, husband is not liable to pay her something other than meher, and she can leave the house whenever she wants to. Okay, and they do not inherit from each other. Suppose this husband dies, the muta wife will not inherit the property of husband, or if wife dies, muta husband will not inherit her property. Nikah muta also does not count towards maximum number of wives. For according to Quran, so if you have four valid marriages and you want to have another marriage, then you can go for nikah muta, because nikah muta does not count toward maximum number of wives. However, similar to normal marriage that are common among Sunnis and Shias, the woman must still observe iddat. The woman must still observe iddat, during which time the woman cannot remarry. This is to ensure that there is no pregnancy from the ex-husband, and thus clarifies paternal lineage. Okay. Nikah misyar. Nikah misyar is a type of nikah in Sunni jurisprudence, popular in Saudi Arabia. It is the same as normal nikah and carried out by normal contractual procedure, but the husband and or wife give up several rights by their own free will. In this marriage, they give up so many rights over each other, such as living together. They may say that by my own choice, tomorrow when you want, you may not live together with me. Okay, equal division of nights between wives in case of polygamy. If you marry other wife, you will spend equal night with me, equal night with her. The wife's right to housing, that you will provide me a house. The maintenance money also, that is called nafaka, and the nafak. And husband's right to homekeeping, access, etc. Okay, these rights can be settled. That is called a nikah misyar, in which you can settle these rights in advance. Since such conditions can technically also include an end date to the marriage, critics equate it to muta. In this case, because you have a right to give up such as living together. Okay, you have a right to living together. You can give up when you have to live together. So it is also a kind of muta marriage, because even end date can be fixed in this case of marriage, that on this date our marriage will come to an end. So this is also a kind of muta marriage. Nikah halala. Nikah halala is a female divorcee remarrying someone else. Okay, nikah halala means a female who has taken a divorce from her husband, she is now marrying someone else, consummating the marriage and then getting a divorce to remarry her previous husband. Okay, this is to circumvent the Quranic prohibition of not being able to take back talaq after third talaq unless the wife has married and divorced someone else. This is commonly practiced in Muslim world. This is a common practice. That means suppose A has a wife B. He divorces her. Somehow he is in anger. He says talaq three times. Okay. He is angry and he says talaq three times, and now the B is divorced from A. It's 4 o'clock. Now he wants to remarry B. He wants to remarry B. He is now repentant. He is saying that I have made a mistake. I now want to remarry B. He cannot remarry his wife before his wife follows halala. Okay, what is halala? B has to remarry some other person. They must have sexual intercourse. The other person must divorce B. B would observe iddat, then she can validly remarry her husband, that is A. This is the procedure of halala nikah. Okay. The conditions to remarry following a divorce and nikah halala are following. The wife should observe iddat or idda after each divorce. The nikah halala must actually consummated. The second husband must pronounce talaq fulfilling all conditions, or he must die. Presumption of marriage. When there is a dispute if marriage has actually taken place, the proof are: whenever there is a dispute whether a marriage has taken place between two parties, two Muslim parties or not, then how do we decide it? That is through nikah nama or register signed during marriage ceremony, because Qazi keeps a record. Or if no such nikah nama is there, oath of the witness present during the marriage ceremony. People who will say that yes, they married in our presence, then it is sufficient. Okay, two male or one male and two females. If they say that yes, their marriage happened in our presence, that marriage will be presumed, that marriage will be valid. However, when these two are not available, there can still be presumption of marriage of the parties. Okay, even if these two things are not there, then also marriage could be presumed. How? If they have been cohabiting as husband and wife for a prolonged period of time, for 2 3 years they are living like a husband wife, acknowledge the marriage has taken place, they acknowledge that they are married. Okay, both of them say that they are married, then marriage is done. Acknowledgement of paternity of child born to a woman takes place. Suppose a woman is pregnant, she delivers a child, and someone comes and say, I am the father of this child, then the marriage will be complete. So we'll now continue in the next class about with Meher and Dower debt.